First case number 116111, State of Kansas v. Freddie A. Thomas.
Thank you, Your Honor. Please the court. Donald A. Anderson appearing on behalf of Freddie Thomas. Would ask for 2 minutes rebuttal.
2 minutes is granted.
Thank you, Your Honor. A brief background how we got here today. On September 16, 2015, Mr. Thomas was at a gathering with his girlfriend and ended up in an altercation with his girlfriend's ex-boyfriend. That altercation ultimately, unfortunately, ended in Mr. Thomas shooting and killing Mr. Saldina. After Mr. Thomas was bound over the district court after a preliminary hearing, filed a motion to dismiss pursuant to immunity for self-defense. That motion was granted on June 8, 2016 by the Barton County District Court. The state appealed. On December 8, 2017, the Court of Appeals reversed and remanded, directing the district court hold a new hearing, making factual findings to resolve any conflicts in evidence and applying proper law regarding self-defense correctly. Approximately 1 month later, the appellee, who's my client, Mr. Thomas, filed a petition for review on his behalf, and the Supreme Court granted that for review on August 30th, 2018. We're here today for oral arguments. Your Honors, it is Mr. Thomas's position that the Court of Appeals erred in remanding the first part, that their issue with the district court's decision that there was no factual findings, and the simple fact that the court couldn't have made its finding without the requirement finding that Mr. Thomas was not the aggressor. That was the state's pretty much full argument at the time of the evidence you're hearing for this immunity on self-defense, was that Mr. Thomas was the aggressor, therefore he couldn't be immune from self-defense based on the statutes. Because of that, or with that argument, when the court held that Mr. Thomas, in fact, was reasonably believed that the two-pronged test that the court applies, that first, that he subjectively believes he can use deadly force for self-defense, and objectively that he can use deadly force. When the court did make findings on the record of why the court believed that he met those two prongs, the court, by virtue of making that finding, told us that the court did not believe that Mr. Thomas was the aggressor in this matter, and therefore he was allowed to proceed with the self-defense argument. The Court of Appeals obviously had issue with the lack of factual findings that the district court had presented in their ruling on the immunity defense. And certainly, by all means, that Mr. Thomas would certainly agree that there was a lack of actual findings in the record for that hearing on the self-defense. However, as just stated, that if the court didn't find that Mr. Thomas was not the aggressor, then they couldn't have made it to the two-pronged test on whether or not his use of self-defense was subjectively reasonable, and also whether or not, if it was subjectively reasonable, then whether it was objectively reasonable. The court found that there was certainly conflicting testimony at the district court level as far as the events that took place on September 11, 2015. However, the defendant did not testify, but his version of the events were introduced through the testimony of Detective Payton, who interviewed him twice prior to this hearing. And during those interviews, both times, Mr. Thomas had relayed to Detective Payton that he was at the home of his girlfriend's daughter, where the decedent had, he found out that day where the decedent had lived. He heard the decedent was coming home. He knew that there had been past issues as far as Mr. Saldana, who was the decedent, making threatening text messages about Mr. Thomas to Mr. Thomas's girlfriend. I apologize. Now we're getting a lot of names, trying to keep it clear for everyone. And those messages had been told to Mr. Thomas, making racially charged threats that he's going to kick his ass, that he was going to come and or kick his black ass. Several text messages where the N-word was used, and so Mr. Thomas was aware of Mr. Saldana's issues with him. Furthermore, Mr. Thomas was aware, and this was testimony at the evidentiary hearing, that Mr. Saldana was known to be violent, had convictions out of Texas. I don't want to overstate that and mislead the court by any means. I don't know that Mr. Thomas knew that there was actually convictions out of Texas, but that information was presented and introduced at the evidentiary hearing. So Mr. Thomas's his statements to Detective Payton at the time of the interviews was that he wanted to speak with Mr. Saldana and see what the situation was, because he didn't want there to be this ongoing issue if his girlfriend's daughter and Mr. Saldana were close and going to be friends. He didn't want there to be any friction throughout the relationship with everyone, so he wanted to basically, as he put it, try to squash the problem. So he remained there when Mr. Saldana was coming. Mr. Saldana had approached him while he was in the yard and came straight at him. Mr. Thomas had pushed him away, trying to stop him from approaching. When he continued to charge, he had drawn his firearm, his sidearm, which he had been carrying all throughout the day, long before knowing Mr. Saldana had even lived there or would be present, something that he did on a regular basis.
Isn't there different versions of the facts as to what occurred at the time of the shooting and just prior to that? And why isn't the competing versions, both are credible, both are from eyewitnesses as to what occurred, why isn't that sufficient to show that the state had met its burden of probable cause, that use of deadly force was not justified? Tell me what happened at this hearing, because I don't understand, when you have competing versions of the same event, why the state hasn't met its burden to show probable cause that it wasn't justified. I don't understand what happens there. And I saw the district court judge's analysis, but isn't that the question? And once you have those competing versions, I don't see how immunity is warranted.
Well, the initial answer to your question, Your Honor, is absolutely yes.
There's clearly competing versions of what occurred.
100%.
And one goes with your version where it might be justified, might not. And there's another version where it clearly isn't, from eyewitnesses. Why isn't that enough to defeat immunity?
Well, and this is where Mr. Thomas concedes that certainly a more thorough, clear record of finding of facts
why I don't even understand why you need it. I just, what I've read here, based upon the different factual versions, I don't understand how immunity survives. Explain to me how it does.
Well, because as the case law states, started in Yulcheris and then also talked about in the case that came out while this was all pending after we were done in district court, before our Court of Appeals oral argument, State v. Hardy, the district court, when conducting this evidentiary hearing, hears the evidence with no favor to the state. And then they hear the evidence, and then they can make a determination and credibility determination. And that's our position, that the district court made their credibility determination and found Mr. Thomas's version of events through Detective Payton's testimony. And through
I guess I look at this as kind of a preliminary hearing standard. The state charges a crime, and at a preliminary hearing, the state presents a case that establishes probable cause? Is there evidence to show the crime was committed and the accused committed the crime? And that's kind of the burden there. And once you have an eyewitness to an event and it establishes some form of credibility, that's sufficient for probable cause. And why is it any different here?
For that,
You don't get into, at a preliminary hearing, you don't get into competing versions of what occurred. That's the burden is to show probable cause, and the defendant's bound over for trial, and that's when you get into the credibility of the competing versions, at least to a greater extent.
I certainly agree with you, Your Honor, that at the preliminary hearing, that is exactly what happens, and the rule is that the evidence is taken in light most favorable to the state. So when there is conflicting testimony, the court is required to take that evidence in light most favorable to the state. However, in what we used to call a Uterus hearing, the evidentiary hearing in this type of motion on a self-defense issue is, and it states here in the syllabus of State v. Hardy, which is this court's opinion from 2017, I believe, excuse me. But it states in syllabus 5, when a district court's ruling entails factual findings arising out of disputed evidence, a reviewing court will not reweigh the evidence. And that to me means that when there's disputed evidence and the district court makes a ruling basically picking a side, then it's not for the Court of Appeals to reweigh that evidence. The Court of Appeals is to accept the district court's version of those events as long as those factual findings are supported with substantial competent evidence.
But that doesn't mean that the district court can't lose sight of what the question is before. And it seems like the district court here may have made the ultimate jury determination of whether there was a valid defense, as opposed to weighing whether there was probable cause. Do you have a thought about that?
I think that's what the self-defense statutes allow the district court to do. That's the purpose of the immunity defense, is if there's true immunity, then the district court can make that determination before it even goes to the trial, before it even goes to a trial of fact. And that's the purpose of the immunity defense, is that it's not the province of the jury if it doesn't need to get there.
Isn't the state's burden to establish probable cause?
The state's burden to present the case is to establish probable cause, and that's what's done at the preliminary hearing. And then as far as the self-defense issue, it's the state's burden to present probable cause that self-defense was not justified.
Right.
So I think the district court was well within its limits in making a determination that Mr. Thomas's, as I will refer to it as, version of the events, that he was in the yard. Mr. Saldana was aggressively approaching him. He tried to push him back. He kept coming at him, and that's when the shots were fired. That with him not being the aggressor, Mr. Saldana coming at him, and the backstory of everything that Mr. Thomas knew, that's where the court, I believe, found that that the state didn't meet its burden of probable cause to show that self-defense was not justified.
But in order to get there, the district judge had to have made a credibility judgment, given the conflict in the evidence.
Yes, I agree.
It's just your view that that's permissible at the probable cause stage on an immunity motion.
Yes, Your Honor. That's what I think that Uterus talks about. I think that's what Hardy talks about when it talks about when a district court. And this is, again, reading from Hardy, when a district court's ruling entails factual findings arising out of disputed evidence, a reviewing court will not reweigh the evidence. I think that's exactly what that says, is that when they make factual findings on disputed facts, that's exactly what they're doing. They're making a credibility determination. If you have story A, B, and C, and the court's picking story A in lieu of the other two stories, and that's kind of what we have here. We had three versions of the events, two Mr. Thomas's, again, that came through the testimony of the detective, his girlfriend, Miss Morero, whose version of the events were substantially similar to Mr. Thomas's, but there were definitely some differences. And then Miss, I apologize, I completely forgot her daughter's name. Is completely skipped my mind.
Melissa Reynolds.
Yes. Because the court heard all three versions of the events, I think the court made a credibility determination, which I believe is proper based on the rulings in Hardy and Uterres.
Counsel, let me direct your attention to I'm not going to call it a finding by the district court, but a statement by the district court that doesn't make any sense to me. The court refers to Officer David Payden's testimony on direct examination, and he says that the detective or the officer, quote, was of the opinion that at the time the defendant was justified in drawing his weapon. That was his direct testimony. Then the court says, if you're justified in drawing your weapon, that's an objective test. That doesn't make any sense to me. The officer gives an opinion. I can understand the officer having an opinion, but I can't see converting that into an objective test. So from where I'm sitting, it looks to me like the district court has garbled up sort of the law that's going on here. That's not an objective test, right?
I think that taking the officer's testimony and his specific testimony would be a subjective test of what the officer believes. And so, yes, I believe that it's the way that the judge stated it at the hearing. I believe that lacks completely being objective. But I think what the judge was saying there was that if this law enforcement officer thinks it's reasonable for it, then
you're saying that the judge was saying this satisfies the objective prong.
Yeah. In essence, he would say law enforcement thinks it's reasonable, so it would, to me, that's objectively reasonable for a citizen to draw a firearm if law enforcement believes it was reasonable.
Is that a fact finding or a legal conclusion?
I think that would be a legal conclusion, Your Honor. I mean, based on the facts that the judge garnered from the testimony of the officer, but certainly that's a legal conclusion.
So if just one law enforcement officer is of an opinion, one way or the other, that's based on an objective test and from your standpoint, conclusive. That's what doesn't make any sense to me.
I think that, and Your Honor, with all due respect, I'm not trying to be curt or short or anything, but I think we do that every day in my line of work. That an officer gets up there and testifies based on his training and his experience. A, B, C, or D happens. So this is what I believe. This is why I had probable cause to search the vehicle, and we do that every day with officers training that they had too many air fresheners in the car, so it had to be a drug runner, and we give deference to those officers every single day in every criminal case I deal with. So what's the difference here in giving? And I know I'm not supposed to be the one asking the questions, but I mean that rhetorically. So I don't see the difference, I guess is what I'm trying to say, is then giving that officer the same deference when he says it's objectively reasonable when he did not say that. When the officer says he believed it to be reasonable to pull a gun, then how can we not say that that's objectively reasonable?
Why does the pulling of the gun matter at all? So what if it's objectively reasonable for him to draw his weapon?
Because that was his initial showing of force. And
that's not what the law is concerned with. The law is concerned with the use of force.
I understand, Your Honor. And
the district judge immediately connected those dots by saying if it's reasonable to draw the weapon, it's reasonable to fire the weapon.
And I think...
But he's hinging that on the testimony of the officer that it was reasonable to draw the weapon. And I'm having a hard time seeing the relevance of that fact to the ultimate legal question.
And I think that they connect, Your Honor, in the sense that probably not the best idea to argue what ifs, but in the event that he draws the weapon and that stops Mr. Sedano cold in his tracks and he backs away. Now are we saying that he wouldn't be justified and wouldn't it be an ag assault at that point? Again, the what ifs. But at that point, in drawing the weapon in a show of force, then again, according to Mr. Thomas and the argument for the version of the facts that I'm arguing, he continued to then come at him in an aggressive manner, and that is why the use of deadly force...
That's just not what the district court found. I'm just looking at the district court's oral ruling from the bench, and he doesn't say that.
again, I do readily admit that the findings of fact are very thin in this case.
And he concludes by saying, that's the reason I'm granting it. As Justice Stegall has indicated, if he's justified in drawing his weapon, an objective person would think that he's justified in firing it. Because if you're justified in drawing it, you're justified in using it. That's the reason I'm granting it. He has just told us that's the reason, and now there appears to be, at least some of my colleagues are expressing concern that how do you go from being justified in drawing a weapon to being justified in actually firing it?
And that's where I'm connecting the dots, Your Honor, that if he was justified in the show of force and then the threat continued, then he was then objectively justified in using deadly force. And that's where I'm connecting the dots on being present and what in the situation. But I do not disagree that there was not more to the. I mean, the court has the transcript, and I'm sure has reviewed it. So I do not disagree with Your Honor's summation of what the actual ruling of the court was.
Okay. Do we have any further questions? Thank you, counsel.
Thank you, Your Honor, or Your Honors.
Thank you, Mr. Chief Justice, members of the Supreme Court. My name is Douglas Matthews. I'm an assistant county attorney for Barton County. Court of Appeals in this case took up the same issues that this court has been discussing this morning and determined that the factual situation presented by the district court was insufficient. It also indicated in its opinion that the district court misapplied the law of the state of Kansas to the facts as they existed. For those reasons, it reversed the ruling of the district court. The state is here to suggest to you today that this court should do precisely the same thing.
Counsel, to get where you want us to be, do we have to either overrule or refine Hardy and the way Hardy said the district court's supposed to process these issues?
Hardy indicates that if you have disputed evidence, it's going to be up to the district court, to the trial judge, to review those facts, sift through them, and apply the law to them. Hardy also indicates that on review, the law is reviewed on a de novo basis. Applying Hardy, no, I don't think it needs to be refined, but what I think happened in this case was a failure of the trial court to apply those standards. The trial court intermixed facts and the law, came to the conclusions that it did, and granted immunity.
Where would you point us to the specific legal error that you're contending the district court made, or errors?
What we come down to is that narrow point in time where we have three individuals, Ms. Moreau, Ms. Reynolds, and the defendant, who is speaking to us through Detective Payton, all giving their versions of events. Now, there are some things that the parties agreed on. The victim, Mr. Saldana, lived at the residence of the Reynolds family on William Street in Great Bend. At the time of this incident, Saldana, was not armed.
Well, I'm sorry to interrupt, but for the sake of time, I was asking about legal errors, and it sounds like you're talking about fact questions.
All right. The district court in this case concluded, as this court has already indicated, that that if you have a display of a weapon, you're entitled to use that weapon. my research doesn't disclose anything in the law of the state of Kansas that comes close to saying that.
So your position would be that's a legal conclusion and it's wrong.
I do, and the Court of Appeals apparently agrees with me. The law as it now stands seems to suggest that you can tell someone that you have a weapon. Under certain circumstances, you may even be able to display it in order to convince someone to back down, back away, disengage, whatever terminology you wish to use. But in this case, the district court basically said, if you pull it out and point it, you can shoot it. That's not self-defense. That's simply saying you're authorized to use a weapon. The trial court also erred, again, in its analysis of the facts. It basically went from point A straight to point B. One thing that the trial judge seemed to focus on was the idea that when Mr. Thomas went to his vehicle, he pulled out a protective vest. The court considered that to be an action in self-defense, but it didn't explain that reasoning.
Do you believe that once you put on Ms. Reynolds and her version of events that you satisfied your burden, for lack of a better way to put it, to show probable cause that immunity wasn't warranted? Is that what you need to do at these things? Is the state has shown a different version of what the accused is attempting to show, and you do that through an eyewitness, and once you've done that, does that defeat immunity?
Depending on the testimony, yes. The state's burden is one of probable cause.
Exactly. So help me with this. When this occurs, this witness testifies. Once that witness testifies that's contrary to the other versions, is that sufficient to defeat immunity? In your mind?
The defense of immunity, yes. Now, certainly at trial, the defense can be raised as an issue for a jury to resolve.
Exactly.
But if you're talking about immunity,
Yes.
the state's position is that it's been defeated.
Doesn't Hardy say that the district court judge is supposed to weigh the evidence and come to a evidentiary conclusion as a gatekeeper? That's what Hardy says.
That's what Hardy says.
So are you now suggesting Hardy's wrong?
No. What I'm suggesting is that the trial court did not do that.
Okay, but in your answer to Justice Rosen's question, I understood you to say that all the state has to do is put on contradictory evidence. And
Well,
if the state puts on contradictory evidence and the district court disbelieves it,
well,
then the state hasn't met its burden, correct?
if the district court does not believe the conflicting evidence, that's part of the process. I presume from the justice's question that we were talking about one witness. If we're talking about more than one, and there is a split of difference regarding who's seen what or who's testifying to what, then yes, the district court is going to have to sift through that and make determinations, and credibility could be one of those determinations. The question is phrased to look specifically at Ms. Reynolds. The district court in this case, to buttress on that, I borrow something that Detective Payton told us when he indicated that during the two interviews of the defendant on both occasions indicated that the first shot that was fired was unintentional. It was accidental. The trial court, for whatever reason, totally ignored that. And yet, as cases from this court and the Court of Appeals have told us, you can't unintentionally intend to defend yourself. There is no such thing as accidental self-defense.
I still don't understand your answer to Justice Rosen's and Justice Stiegel's inquiries concerning conflicting credibility among witnesses, okay?
Okay?
So, are you saying that if two witnesses give contradictory testimony about the events, the judge is supposed to let that conflict go and be decided by the jury, even though there's this self-defense immunity claim?
If you are talking about a hearing on immunity, no. The trial courts have been instructed through Hardy and following opinions to take the substantial competent evidence before it and make it and sift through those facts. You're looking for substantial competent evidence.
So it's okay for the judge to say, I don't believe A, I believe B, and under B's version of the facts, self-defense, the state does not have probable cause, and so immunity will be granted.
That's one way to express it. Hardy expresses it by saying you're looking for substantial competent evidence. If one person's testimony is substantial competent evidence of what happened, then that's what the district court should be looking for.
I think we're trying to differentiate between whether these motions for immunity, self-defense immunity, are in effect probable cause hearings, or are they really mini trials where the district court serves as the jury in sifting through conflicting facts? You see the distinction here?
I can only-
Justice Rosen's question started this as a sort of like a probable cause hearing, and you said, oh yeah, this is a probable cause hearing. Well, when you've got conflicting evidence, which you would often do in these kind of cases, seems to me to be a different animal. And I'm trying to figure out whether Hardy articulates that different animal correctly, or do we need to do something different? So I get back to my question. From the state's perspective, is this proceeding, a motion to invoke the immunity, is that just a mini trial where the judge serves as the jury, finds the facts, and then we're stuck with the facts and we apply the law on review?
Sir, I can only tell you what I've seen in Barton County and what I've read about in the appellate decisions that have been released. I think my answer to that question would have to be yes. The burden is on the state. We have to show a negative. There are no presumptions in favor of the state. A prosecutor is not going to come before a court and assume that if I put on one witness and some exhibits, or two witnesses and a couple of exhibits, that's going to be sufficient. It's my understanding that one of the cases you're going to be hearing this morning involved a proceeding on immunity that lasted the better part of 3 days. We're talking about a probable cause finding but no one out there, at least no one that I know, is going to assume that all you have to do is put a witness on the stand, have the witness say something, and the judge is going to say immunity is not granted. A prosecutor is not going to want to take the chance on something as important as this by simply suggesting this is just a probable cause hearing when there are no assumptions to be made in favor of the state.
But from the perspective of the reviewing court, the appellate court, conflicting evidence, the judge makes a determination of the conflict, particularly on credibility determinations. Once those determinations are made by the district court, the reviewing court is stuck with those.
If the court believes that you have sufficient facts upon which to draw conclusions of law, and prior opinions of this court, and again the Court of Appeals, have said that as well. If you have substantial competent evidence and you can adequately apply those facts, that substantial evidence, to the law, then you have a proceeding that is sufficient. If I understand the tenor of your question, however, no, prosecutors are not going to come in with a bare minimum and say, this is all we need to establish probable cause or to defeat immunity.
Right, and that gets me back to my notion that these hearings are a different animal than just a probable cause hearing.
Until this court changes the burden,
Well, the statutory burden the state has to meet is probable cause, right?
and that's what this court declared in, I'm going to mispronounce it, Atreides and Hardy.
But the distinction, as opposed to calling it a probable cause hearing, might be between a preliminary hearing where the state only essentially has a burden of production as opposed to a burden of persuasion. I mean, in a preliminary hearing, the state just needs to come in, and it doesn't matter what the defendant does. If the state puts forward sufficient evidence to get across the probable cause threshold, the defendant gets bound over.
Correct.
Whereas here, at least under Hardy, the distinction would be that there's actually a fact-finding going on by the district judge. I think that's essentially Justice Biles' question. Is that?
And I would have to agree with that. In a preliminary hearing, you can present a weak case. You can present almost no case at all. And the presumption is still going to weigh in favor of the state. Those presumptions do not exist for an immunity hearing. There are no presumptions laid out in favor of the state. The court is not going to assume that even though it's a weak case, the state prevails.
In essence, you have to try the self-defense defense preliminarily. And
I cannot speak to what this court intended,
yeah,
but practically speaking,
that's what's
that's
happening.
what happened.
Well, you
That's
have
the
to
way-
try. I'm sorry.
I'm sorry, that's what Hardy's being read to mean, is that you don't take any chances. You have to go full on pretty much in the immunity hearing.
Considering the tenor of this case, we're talking about a murder charge. No, nobody's going to want to go out there and simply assume if I put on the minimum of evidence, I'm going to prevail.
Yeah.
Whether
And
we
And
like-
so, as a practical matter, is the line between proof of probable cause versus proof beyond a reasonable doubt almost non-existent as a practical matter?
Practically speaking, again, I can only tell you what I've seen in Barton County. We're getting close to that.
And how under the statute do you stay at a probable cause proceeding? And does that require us to change Hardy? To ratchet it back?
Hardy gives us an outline, and I'm not going to try to, I wish I could establish the policy of the state of Kansas, but I think a little more guidance is needed. Right now, the district court judges are being told, evaluate for substantial competent evidence, make conclusions of law. What we haven't heard yet is just how much evidence or what kind of evidence in this court's view establishes substantial competent evidence. We know at the preliminary hearing stage, it can be pretty much non-existent. Hardy hasn't gone that far, and the cases following Hardy haven't gone that far, because Hardy's basically said, do this, find the facts, and then draw your conclusions of law.
If the district court applies the wrong burden of proof, regardless of what it says it's doing, that's an error of law, right? If a reviewing court determined that the district court actually applied a beyond a reasonable doubt standard,
Then that's definitely an
That would-
error, because that goes beyond what Hardy said and Ulteris said this district courts had to do. Probable cause is a lower standard, it's a lower burden. It's the state's burden nevertheless, but it's lower.
the state, I mean, conceivably, given the gap between the standards, the state could survive a motion for immunity pretrial and still lose in front of the jury because it has a higher burden in front of a jury.
And this court and appellate courts have anticipated that. What we're saying is, if we're talking about immunity, and forgive the phrasing, but we're talking about all the marbles. We either have immunity, in which case we don't have a trial, or immunity has been defeated for purposes of deciding whether or not we have a case to try, but that doesn't mean your defendant still can't raise the issue before a jury.
Or self-defense generally. Obviously, they can still win on reasonable doubt standard on self-defense.
Absolutely.
Yeah.
Let me raise a factor that might further complicate things. And that's the point that was raised, I think, in the defendant's brief, that in such a hearing, the judge makes, in effect, a negative finding because it was the state's burden that it failed to meet. And in looking at some past case law, McCracken, where at that time we had put the burden on the defendant, and the district court found he had not met his burden, this court said that was a negative finding. And as you know, that changes what our review would be. We will not disturb a negative finding on appeal absent a showing of an arbitrary disregard of undisputed evidence or some extrinsic considerations such as bias, passion, or prejudice, which seems to be putting an even greater burden on the prosecutor when we're faced with something like we have here. So could you address that? In other words, is this a negative finding?
It is, and I will agree with you that in some respects it complicates the duties that we have to perform. How do you prove a negative? We can put on the evidence, we can listen to testimony, we can present exhibits, a mini trial in effect, but nobody knows precisely what that is. So what is the standard, aside from what you've already declared, for proving a negative? How do we go about doing that? And unfortunately, that's where we get into the mini trial aspect of an immunity situation. How much evidence is going to be sufficient? Or, to put it contrarily, how much evidence is insufficient? I'm sorry, I'm not equipped to answer that question. The only thing I can tell you is, if I believe I have sufficient evidence, witnesses, exhibits, and so on, I'm going to go into a courtroom and I'm going to tell a judge, for these reasons, here's witness A, here's witness B, here's exhibit 1, here's exhibit 2. These help to establish that the defendant may or may not have had a subjective reason to believe that he or she had reason to defend themselves. Objectively, he or she did not, and here are the reasons why. I would agree with you on this point. Hardy gives us a framework, but if we're going to understand just what the boundaries are, we're going to need a little more.
What about the issue, I believe has also been raised by opposing counsel, and that is you did not object to any of the findings or the conclusions made by Judge Swati in this case?
I did not.
What do we do with that?
I think you take the record as it is and you declare it to be insufficient. Court of Appeals did precisely that. There are several issues out there that couldn't have been decided and apparently weren't decided on the record presented to the trial court. As I indicated earlier, when the trial judge made his final determinations, the one thing that he focused in on was the use of this protective vest. Now, we had all sorts of information about going to a vehicle, coming back from the vehicle. Were words spoken in the front yard of this residence? Were they not spoken? What is a clearing action? Was it grabbing someone by the throat? Especially in light of the fact that the defendant denied any such action. And then we went straight to, you're immune because you're carrying a weapon, so you can use it.
What about your obligation to seek more complete findings What about your obligation to seek more complete findings if you think they're insufficient to settle the matter?
I would agree that if one party or another believes that that's the situation, we should make that request.
At the district court.
Yes.
So what do we do with it on appeal when you haven't done that? Do we always just fix that for a party who has not performed that task in the district court?
In prior cases, you have, yes. Courts at this level and at the Court of Appeals have said the record is insufficient, it's devoid of information. The particular terminology escapes me, but if the appellate court believes that there simply isn't enough to work with, yes, I think the obligation at this point is, rather than act as a finder of fact, you send it back and you say, let's find some additional information.
That is in tension, of course, with our other cases, that say that we assume that a court has made the fact findings necessary to arrive at its legal conclusion. So it depends on whether you view this as an incomplete record or a silent one, I suppose, on certain issues.
Well, I think, given what the Court of Appeals in this case said, both Mr. Anderson and I were acting as advocates for either of our sides when we presented this case to the Court of Appeals. Mm-hmm. Both of us argued these are the facts. Of course, they're facts favorable to us. Mm-hmm. So we believe these are the facts you need to either sustain the district court's action or to reverse it. Mm-hmm. The Court of Appeals can't find the facts, but it was dissatisfied with what it had. Mm-hmm. So it invoked Rule 165 and said, let's try that again.
Okay, thank you.
Do you have any further questions? Counsel, do you need 30 seconds to wrap up? Or do you think you've made your points?
I think I've done everything I can, sir.
And what are you asking us to do?
Sir, I'm asking you to sustain the actions of the Court of Appeals and either return this case to the district court for additional findings or simply to reverse and determine that the findings of immunity or the granting of immunity was not sustained by the law.
Thank you.
Thank you, sir. Your Honors.
Reserve 2 minutes for rebuttal.
Thank you. I don't know that it's in so much as rebuttal, but just to reiterate, and based on some of the justice's questions as far as whether the immunity, the evidence you're hearing that district courts are holding, specifically that we had in this matter, whether it in essence becomes a mini trial, and it takes that. It takes the determination for the finder of fact, ultimately the jury normally, whether it takes that away from the district, if the district court takes that away from the jury, if that's proper. And I believe that's exactly what Hardy discusses and anticipates. In Hardy, it discusses the significance and the difference between a affirmative defense and immunity from prosecution, and stating, and I guess it seems somewhat silly to read your all's words back to you, but stating we need to look no further than the plain and ordinary meaning of the word immune, however, to conclude that taking the case from the jury is precisely what the legislator's use of the term signifies. And that's exactly what the court here did. It made credibility determinations and ultimately took that decision from the jury based on the finding that it believed Mr. Thomas's versions of events over the other witness, who was clearly compassionate towards the decedent, and found that Mr. Thomas acted subjectively and objectively reasonable by using deadly force. So for those reasons, Your Honor, we would ask, Your Honors, we would ask the court to overturn the Court of Appeals ruling and affirm the district court ruling in this matter.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.